Lord, there were 4 offences in the FIR: 64(1), 238, 239, and 351. If an offence is punishable less than 7 years, you should give me a 35(3) notice, comply with Arnesh Kumar. I'm not even saying that has been breached. That is admittedly breached. Something more serious, the breach is, there is a jurisdictional bar to arrest somebody for an offence which is non-cognizable. 35(2) is a non-cognizable offence. 35(2) says there is a bar on the police to arrest for a non-cognizable offence. How is it that, however serious this offence is, whether she's an Indian or a US citizen, merely because there is one cognizable offence, you go and arrest me? The question is whether you could have arrested me. No one is for a minute saying no incident has happened. There is an incident which has happened that is being investigated. We will be happy for it to be investigated by a special agency like CBI. Orally remarked on the previous statement that rape of a foreigner is a very serious offence. I just want to make one clarification. It was carried all over the media. One clarification. Yes, ma'am. I am not for a minute saying that no such incident happened or whether it was consensual, non-consensual. I'm not going into that now. The only question is not whether, however serious an offence is, can the state violate the rights of accused with impunity? Yes, my simple case is.
I will definitely answer that.
Yes.
But you tell me, these homestays need to be regulated, because they have mushroomed to such an extent that we don't know where are they and what happens there. So everybody's security is at risk.
No, there are thousands of homestays.
That's exactly.
We are a licensed homestay.
That's all licensed. Yeah. Gram Panchayat license kodtare. Yes.
Lord, can I just take your lordships to the FIR and just point out one thing so that the state has an answer on that? Just please come to the FIR at page 37. Lord, there were 4 offences in the FIR. Please come to page 37.
Yeah, tell me.
64(1), 238, 239, and 351. 64(1) is rape. 238 is destruction.
Rape obviously is not against you.
Now, in her complaint itself, she says that the incident happened between 1 to 3. She identifies who it was. A bald man names the accused. Lord, she says 17 minutes after the incident, thank you for giving me Wi-Fi access. You're ready. You can upcharge me because you have been helping me out. That WhatsApp message, Lord, is at page 51. Your lordship will only see at page 51. She says, thank you. I just received Wi-Fi and I'm now back up and running. Do let me know or feel free to send me a request for the dollar amount for me to pay you back. And you can absolutely upcharge me as you're helping me out. This is 17 minutes after the incident. I was not at the site at all. Now, please see, Lord, 12th. So between 1 to 3, the incident happens. 4 o'clock, I come to the property, I give her Wi-Fi. She specifically in a complaint says, I did not disclose to the owner at that time what had happened. On 12th in the night, for 16 minutes, she has spoken to her friend on call in the US. Again, 8 minutes. 13th, she herself states in her complaint that she has received call back from the same friend. 14th, she gets a call from the US consulate. She's in touch with the US consulate as well. On 13th, 14th, CCTV footage captures the family and the victim going out. We have written to the sub-registrar office in the district lot to secure the CCTV footage and keep it safe. 13th, she goes out. 14th and 15th, she goes on a solo excursion. Everything captured on CCTV. 16th lot and then 18th, the FIR comes to be registered. FIR is for 64(1), 238, 239 and 351.
Yes.
Now, on 18th evening, I'm picked up. 19th at 5 a.m., the arrest is shown. Now, Lord, all the 3 offences, which admittedly at its highest, even if they are attracted, against me are classified in the BNSS as non-cognizable and bailable. Offenses. So, on 19th at 5 a.m. when I'm arrested, I am arrested for a non-cognizable bailable offence. Lord, please remember, not in the Rajya Sabha case which your lordships had decided, it is not my case that no FIR could have been registered. There is rape, so cognizable and mix of cognizable, non-cognizable, FIR gets registered. The question is, could I have been arrested for what is admittedly a non-cognizable bailable offence?
You're still in custody?
I'm out on custody, Lord. Your lordships had pointed out why compensation to repair the homestay, Lord, not to repair the homestay, to repair my reputation. Lord, I have been arrested for a non-cognizable, bailable, vicarious liability has been imposed on the owner for having helped the victim. The victim has travelled with the accused on the very next day, has written. Now, please see what the parents on 13th. Just see this email communication at page 53. If Wi-Fi has been cut off for 3 days, then she's been locked in a room. Just please see page 53. This is an email communication from her parents in the US she has received, which she has replied in 30 minutes. Just please see 53. Lord, your Lordship will see at the bottom the date, April 13th at 9:12 a.m. This is on the following day. If she had no Wi-Fi, she would not have received this email. She would not have replied. Just please see what the parents say. So and so, I'm not taking the victim. The urgency to connect with you is because we are very concerned about you and want you to come home safely. Your trip has taken a toll on us. Your mom is running back and forth to Haley's weekly, caring for this constant worry about you is wearing on her and me. And then she has to field calls from friends that are seeing your posts and are also very concerned. You are halfway around the world without anyone else we know in the middle of nowhere. Why wouldn't we as loving parents naturally be worried about you? Now, please mark, this is very important. We don't understand why you cannot grasp that. Also, the issue with antidepressant meds amplifies this whole concern. Your Lordships are there, Lord?
Yes, yes.
I know more than you might believe about this subject and have known many people that stop them like you did and end up in a world of hurt with extreme mood swings. Please consider going back to a smaller dose, maybe 0.5, 0.10 mg if you're experiencing negative thoughts. As far as me dismissing you, that couldn't be further from the truth, and so and so. She replies to this, Lord. That reply is at page 52. 45 minutes after this incident, she replies to her parents, which is forwarded to 7 other friends. In this entire email, there is no mention of any incident. She didn't maybe perhaps to not disclose it to her parents, but I want to only show your Lordships at page 53. Just please see page 53 at the top.
Yes.
I'm working, she's replying to her parents. I'm working my job right now. My work understands me and they are extremely happy for me and have blessed me too much by letting me stay here longer. And that I'm allowed to work. I don't even have to work, but they're letting me and it's wonderful. I'm able to make my American living here at least for a few weeks longer. Why is it that you want me to come back to the US so urgently when I'm learning and experiencing firsthand that miracles really do happen? God really does exist. And I'm finally, for the first time in my life, feel healthier than I ever have. No constant body pain. I have no want, thought, desire for abusive, addictive substances. My bowel movements are aligned and I'm so much physically closer to God. The unenlightened so-and-so would have continued to put up with this trend of trauma and abuse. I am finally taking a stand and being who I truly am for the first time in my life. This happens on the very next day. Now, please see what her friend says. Not her friend writes to us. Your Lordships will see that email 57. She names this woman who has sent us an email as a friend in the complaint. Please see what the friend says. At 57. Dear Aparna, as informed to you over the phone, so-and-so and I have been friends for 2 years and she has visited me multiple times in India. However, from the day I have known her, she has always been an enthusiastic, energetic and friendly person. I have a personal bond with her and think of her as my sister. However, during a most recent visit to India in March 2026, I came to realize that she has abruptly stopped taking her prescription medication, also known as escitalopram, used to treat major depressive disorder and generalized anxiety disorder. I understand from my discussion with so-and-so that she suffers from ADHD, OCD, anxiety and depression. I believe she had abruptly stopped taking her prescription medication. Her behavior has taken a turn for the worse. This is something I observed when she landed in India in March 2026. She's been experiencing emotions in the extremes, such as extreme happiness, extreme sadness. She seems to be showing paranoid thoughts and imagining things such as seeing visions and experiencing the presence of her late grandparents and her late boyfriend and becoming upset with me for not believing her. Her parents and her close friends have also observed extreme changes in her behavior and had requested my help in...
How is all that got to do with the allegation now?
Lord, my point is very simple. Now your Lordships have seen what were the 4 offences that have been named, that have been added in the FIR. Admittedly, all those allegations against me, the allegation being that I've suppressed this case.
You're on bail, right?
No, it's not about bail. No,
then,
it's not on bail.
Then what?
Then please see this. My prayer is for a declaration that the arrest is illegal to stay the FIR insofar as 64(1) concerned against me. No, it's not about bail. There are pre-arrest safeguards and post-arrest safeguards. I'm not coming saying that my post-arrest safeguard of a written grounds of arrest is not given me, therefore it's violated. The pre-arrest safeguard is, Lord, if an offence is punishable less than 7 years, you should give me a 35(3) notice, comply with Arnesh Kumar. I'm not even saying that has been breached. That is admittedly breached. Something more serious, the breach is, there is a jurisdictional bar to arrest somebody for an offence which is non-cognizable. 35(2) is a non-cognizable offence. 35(2) says there is a bar on the police to arrest for a non-cognizable offence. How is it that, however serious this offence is, whether she's an Indian or a US citizen, merely because there is one cognizable offence, you go and arrest me? Because of the arrest, I have suffered humiliation. Booking.com, on which I have my listing, has written to me saying, we are going to permanently cancel your listing because there are sexual misconduct allegations against you. Not vicariously, not the owner. Not if this trend is continued, then nobody can do business in India. Whatever has happened, whether regulation should happen or not, that is state's responsibility, executive's responsibility. They're doing it. They need to crack down on homestays which are operating without license. We had a license. We have done the due diligence. We have done it. There's an unfortunate incident that's happened.
We'll see. Yes.
Look, your lordship will see. Your lordships will only see, Lord, what has happened in the remand application. Also, I have shown. Your lordship will see the remand application.
We'll see.
At 5 a.m. I'm arrested. At 11:30 in the night, I'm produced before the magistrate, not for remand purposes. At that time, 3(5) is added in the remand application for the first time. 3(5) is common intention to rape. I'm not even in the site. Supreme Court says two things to invoke common intention. There has to be prior concert and there has to be physical participation. That's the only way on which they've arrested me.
We'll see. Yes, sir.
We are not saying there is a common intention to rape. We are saying common intention to destroy the evidence. We are saying common intention to threaten the witnesses. The very fact, my learned friend has received the copy of the grounds of arrest. We have said what is the allegation against him. If he is not taken advantage of that and then wanted to come here and cry, we can't help. We have very specifically said what is the allegation against him. And the grounds of arrest we have served to him. The copy is there and shows that what is the allegation against him. That's one. Second, my learned friend is speaking about depression. Is he saying that she was not subjected to sexual assault? I'm sorry.
No. Depression is a separate thing. That has nothing to do with what he is wanting to project. That is accused number one will.
No, I started by saying I'm not for a minute saying.
No, in fact,
not for a minute saying that there is no rape. There's someone arrested. He's in custody. The question is not whether an allegation of rape can stand against the owner.
We are not saying. We are not saying, Your Lordship. The very day she came into the state, she was subjected to sexual assault. She communicated. It's not that she never communicated. She did communicate.
To the owners.
Not to the owners.
Then?
To the parents.
That is in the US.
Yes. At the back, because she did not know. In fact, the conversation between them saying that, okay, I will tell them. And subsequently, friend tells the owner that something like this has happened. After that, she's supposed to go. And, in fact, everything is there in the chat before she files a complaint. She collects even the tissues which she was the accused used after commission of offense. She collects everything. She carries all these documents with her. She wanted to. It's not that, my lord, she happily went out and etc. The very fact that she shifted from tent to the house is to say that she wanted to get locked and stay inside. She did not know. She was subjected twice by two different people.
Please come to the
and she collected the mat.
For a minute, I'm not appearing for the named accused who is apparently.
No, he's telling the facts.
I'm telling the fact. Yes, I'm telling the fact. She wanted rape. She did not take. She has not taken a bath. She wanted to preserve the evidence. She says all these things. She collects the rape kit. Then the arrangement was made to shift her to Mysore, and then she files a complaint. It's not that, my lord, in the remand application and the grounds of arrest, we have specifically said what is the role. We have not said that he's committed a rape. We have said only this. We have said that, in fact, the grounds of arrest have given the copy. It very specifically said he is the person running. Chances of destroying the evidence, chances of threatening the witnesses. Of course, it is his property. The accused are there. Not all the accused was arrested. Second accused got arrested subsequently because the DNA. Now the DNA is matched with one of the accused. Second DNA was not matched. Therefore, all these things was there. So it is our obligation to protect. We have done it.
But my learned
and the grounds of arrest is, if my learned friend has read the grounds of arrest, he should have filed an appropriate application before the court. He did not even file a bail application.
Not my learned friend not answering the argument. I'm not on a post-arrest violation of a safeguard. There are post-arrest safeguards, grounds of arrest. I'm not on that. I'm on a pre-arrest safeguard, whether you had the jurisdiction to arrest me in the first place. There is a bar, all offenses. And my learned friend supports my case if he says that there was a common intention to destroy evidence. Not if there is a common intention to destroy evidence, that does not change the classification of the offense from non-cognizable to cognizable. The question is whether you could have arrested me. No one is for a minute saying no incident has happened. There is an incident which has happened that is being investigated. We would be happy for it to be investigated by a specialist agency like CID. Because in a complaint, she says, I was served with a welcome juice, was a guava juice. In the seizure form, in the property form, what has been seized is pomegranate juice. If that is the level of investigation which that Kutta police station is doing, then not necessarily it should go to a more specialist agency. Let this investigation be done properly. I'm only saying.
We'll see.
Yes, but I'm only saying, your lordship will see the complaint once. In the complaint.
Heard reserved. Yes.